Good morning. Please be seated. This is the time set for oral argument in Wozniak against Ballet, Arizona, our cause number 1CA IC140022. Counsel, as you're probably aware from past experience and certainly from the order-setting oral argument, we have reviewed the briefs in this case carefully and conferenced the case before beginning, so bear that in mind as you begin your presentations. We are being videotaped today, so if you'd announce your own name and that of your client when you approach the podium, we'd appreciate it. Each side will have 20 minutes for oral argument, and as much time for rebuttal as you wish to save is up to you, but when the clock hits 0, we're done. All right, with that, we can begin.
Oh, okay, I'm sorry. May it please the court, my name is Harlan Crossman, and I represent Mr. Wozniak, the appellant in this particular case. The issue in this case is strictly average monthly wage. What was Mr. Wozniak earning at the time? He was on a contract of employment of $770 a week. Now, this was for approximately 9 months, because that's all that the ballet school went at that time. And he was injured. And the question is, what do we do? The answer is we've got a case right in point, Powell, which talks about teachers. Teachers are a 9-month salary, and they can work a little afterwards. So, but divide the average monthly wage by 9.
You say that Powell's directly on point. I noticed that you refer to Mr. Wozniak as working at a ballet school. In fact, he works for Ballet, Arizona as a dancer.
That's right.
So he is a performer. Does that distinguish from a teacher in Powell?
No, I think the answer is he's on a contract.
So is the distinction then being on a contract?
Yeah, no, that's not a distinction. That's what makes it the same as Powell. Teacher, they say, can work in the summer when she's off. Same way with a dancer. He can do anything, work in a grocery store or work anything else.
So anyone under contract would qualify as a seasonal worker?
Oh, that's exactly right, Judge. And I call your attention to ARS 23-1041C. And there's some, and it talks about working under contract by which he's guaranteed amount per diem or per month, notwithstanding the contract price for such labor, the employee or his subordinates or employees working under the terms of such contract or his or their dependents in case of death shall be entitled to receive compensation on the basis only of the guaranteed wage as set forth in the contract of employment.
Of course, counsel, that statute said per diem or monthly.
He's
Guaranteed.
getting paid weekly?
Weekly. So
Well-
does he fall within the statute?
Oh, Your Honor, I think
The spirit? Does
that's
he
the difference
does
without.
he fall within the spirit of the statute?
Yeah, no, I think it's, the contract of employment is the statute. And I say you turn around and you take his weekly salary of $770 a week and you multiply it times
Are you saying that the
4.33, which is how many weeks there are in a month, and it comes out to $3,336.41.
are you saying that the per diem is $110 a day? Is that how you're getting to subsection C?
No per diem, contract of employment.
Right.
Yeah, okay, and so that's what his salary is $770 a week, okay? And then you multiply that times 4.33.
But why? Why don't you? Okay, and then keep going. What's your
Okay,
next step in the math
multiply
equation?
that comes out, there's 4.333 weeks in a month.
Right.
So you take the 770, multiply it times 4.333, and you get 3336.41. All right?
Now,
Then you add.
isn't there a problem here because he's not consistently working those 4.33 in each month?
Well,
He's not, because this is an intermittent, I'm not intermittent, there's some weeks that he takes off, correct?
that's only at the end of the year. By that, well, I shouldn't say the end of the
I
year.
thought that there was certain weeks during the term of the ballet contract where they don't dance, and then therefore he's not paid. That's what the testimony was at the hearing.
I don't,
That these are, and that's why the contract says 32 non-consecutive weeks he's being paid.
well, that's
Non-consecutive.
because it could run into May or a little later into June, if you will. Okay? And they're not sure how long it's going to go.
Okay, but regardless, what your point is here, isn't your point here is that the ALJ used the 12-month denominator in error? Is that what you're saying?
Sure. And she didn't know what she was doing. Just look at her decision. I mean, she didn't know. As I say, she didn't follow the statute. And clearly, we have somebody why it should be any different than the teacher when she's under contract also. Now, there is a case, you could turn it around, the Pettis case. The Pettis, the man worked for 12 months a year, but then 2 months of the year, they closed the office down. And the court said, all right, we'll divide by 10. If you turn around and use that on the ballet here, then you subtract the last 3 because they don't need dancers. Okay, so that's the other way of looking at it. If you want to get to the 9-month basis.
Well, the problem with it, or one of the problems I'm struggling with is it talks about the seasonality exception. I mean, here, this is for a season. The ballet, it's a ballet season. That's what the contract was written for. So why doesn't this fall into the seasonality exception?
Well, this
To
is
the average
clearly,
monthly
this is
wage.
clearly not a seasonal thing. They could, I mean, when you pick flowers or pick tomatoes, they only grow sometime. You pick alfalfa, they only grow.
What if the-
Dancing you can do all year long.
What if the ballet season only lasted 3 months? Would he be seasonal?
No, I can't see where that is seasonal, Your Honor.
What if the ballet season were 2 weeks?
No, then I think you'd use one of the others which said less than a month.
So in no circumstance, no set of facts about the length of the ballet season could make Mr. Wozniak more analogous to a farm worker than a teacher.
Well, the problem, that's right, the problem is you turn around and when you divide it by 12, and then you give him an average monthly wage and pay him 2/3, 66 2/3%, he's not getting 2/3 of his $770 a week. He's getting less. And he's supposed to get that amount while he's been injured.
But we seem to have 2 lines of cases, right? We have the seasonal employment cases, and we have the teacher case.
And which seasonal employment are you talking about was under contract, Judge?
Well, I'm talking, for example, about somebody who picks cotton.
All right.
If you have somebody who picks cotton for a brief period, we call them seasonal. If you have a teacher who doesn't work all year long, we don't call that seasonal.
Correct.
What's the rationale for the distinction?
I'm not so sure. Well, seasonal is clearly, it only can be performed for that time when the plants are growing, whatever it may be, all right? But dancing and teaching, they say during the summer, she could go out and get another job. Same with dancing.
Well, but how is that the case? I mean, it's not like a ballet dancer, and frankly, maybe there are types of dancers that are sufficiently generic that they can go out and, work in clubs or something and dance 12 months of the year. A ballet dancer dances when the ballet is performing, correct?
Correct, and they can teach.
So if the ballet is performing 9 months of the year, they're dancing 9 months of the year.
But he's also, if you look at it, he was teaching at the other ballet studio, and that's why there's an additional average monthly wage of $1,000, because he was teaching.
But how's that relevant to the test of seasonality?
Well, I think seasonality is not intended for a teacher. It's not intended for a ballet person.
So this court just keep going. We go teachers, ballet dancers. What's the next profession to come before us? Doesn't it seem a little bit odd? I mean,
Isn't it arbitrary?
As to what is seasonality?
Is the question.
yeah.
Yeah. No, I mean, that's what he bases his whole brief on, is seasonality. Never heard a teacher talk about being seasonality, even though it's only 9 months, nor a ballerina dancer. Now, somebody who works in the field, yeah.
But here's, and talk about arbitrary, but in Powell, unless I'm misreading the case, if the teacher in that case had actually been paid on a 12-month contract, then it would have been divided by 12 months.
Well, we don't know that, Judge. And,
Well, why wouldn't you have?
well, let me read the rest of the Powell case, the bottom. In conclusion.
Right, is that Court of Appeals or Supreme Court?
This is Supreme Court. We therefore hold that the average monthly wage on the petitioner's employment was covered by the contract by which she was employed, and that her average monthly wage should be fixed by dividing the amount of the contract by the period of employment, which was approximately 9 months.
But hypothetically, I'm just saying if she was paid,
Let's assume
Of
he
course.
was, somebody was
12
injured on the
months.
first day of the job.
well, let's assume Mr. Wozniak's contract here provided for, it wasn't a weekly payment. It was just a monthly payment, same amount of gross wages, but divided over 12 months. The divisor would be, the denominator would be 12. What would be, so why should,
Well, the
why should he
contract,
get a higher benefit just because of the contract? Just
well,
because of
the contract, does that mean he can't work the last 3 months? Or he's just paid, he could work the 3 months as teaching ballet?
I thought, yeah, the testimony, correct me if I'm wrong, I believe you asked him a question at the hearing as to whether he could find employment during the summer, and he said no.
I think ballet employment. Just not that many ballet studios around.
And what's the universe? Is it Phoenix, Arizona,
No.
United States?
No, it's Phoenix.
That's the universe? Yeah, I mean, do you have,
It's not the universe, but that's the area of employment that we're discussing in workers' compensation, because that's where,
so in all cases, like, is it limited to a geographic area?
oh yeah. I mean, I think Arizona, there's case law, it's an Arizona statute. It's strictly statutory. There's no common law about workers' comp, Judge. Strictly statutory.
But that doesn't answer the question of where he could work. There are plenty of professions, and ballet might be one of them in some markets, where the dancers are able to get work in many jurisdictions.
What, you mean like go to New York?
Yeah.
That's sure possible. I agree with you. So I guess you could say the answer is it's available, but not within this average monthly wage area that we're dealing with.
Go ahead, counsel.
Okay, so I mean, I seem to get a feel here that you're trying to limit the Powell case to Powell. Well, I think that should be, with all due respect, the Supreme Court to do that, rather than the Court of Appeals. And I think we're bound by the statute.
I'm
Statutes.
still trying to figure out the distinction between teachers and farm workers. And you seem to say that Mr. Wozniak could never be like
Well,
a farm worker.
farm worker doesn't have a contract.
Wait,
Farm worker
let's
goes
back up. Let's
to
back up.
Yuma and
Yes,
yes,
don't all employees have a contract?
No.
Are you saying a written contract or
Written.
every employment relationship involves a contract?
That's 23-1501. That's
everybody has a contract. What, a daily contract?
Well, it depends. If I go to work for McDonald's, they agree to pay me
Right.
minimum wage, right? Or whatever. That's a contract.
even an at-will employment arrangement is contractual, and that's confirmed by a statute in Arizona. So everybody has a contract. What's the basis for the distinction between teachers and farm workers?
The Supreme Court case, I mean, I don't,
Well, but what was
Let's
the
assume
Supreme
somebody
Court's?
goes to work and hurts the first day.
Hey.
You say their average monthly wage
Sir?
is 1 day?
What was the Supreme Court's rationale? It seems to me to be an arbitrary distinction, perhaps based upon 9 months seeming like more of the year than 2 months, but that rule is never expressed in the case law.
It's not codified anywhere. You said that it seemed like we were trying to go after a certain thing. What we're trying to do is reconcile a group of cases that are out there that seem to cut against each other at times, and that's what we're asking you to do for us.
Okay, well, there are not the cases with the contract of employment. Now, you turn around and say, oh, they're all contract of employments. That's not what this court said, Supreme Court. It said a written contract of
Well,
employment.
the statute that says that was enacted 1996, 1997, I think. So does the Supreme Court's view of the contractual nature of employment back then still hold water?
I think so. I
Fine.
mean, a teacher clearly is working, 9 months. I mean, what you're saying to me is everybody is under a contract of employment 1 day. Then how do you determine their average monthly wage? They're under a contract of employment. Do you go to the statute?
Well, under subsection B, you follow subsection B because they're
Worse
working
than less than 30
less
days?
than 30 days, perhaps, arguably, I guess.
No, for some reason, I do think like you're looking for a way to make a distinction, and I don't think there is any. I mean, and I was very surprised when you asked for oral argument, when neither one of us did. But I respect your right to do that. But it really is a lot simpler than you're attempting to make it, with all due respect.
I'll bet that opposing counsel takes a different position than you are in that regard.
I'll save the rest
think
of my
it's simple,
time.
too.
I'll save the rest of my time to respond.
Counsel, thank you.
May it please the court and Mr. Crossman, Todd Lundmark representing the respondents. The parties really do agree on one very fundamental point. The average monthly wage should reflect the earning capacity of the claimant in the occupation in which he or she was injured. We customarily rely upon that claimant's earnings record to make that determination, but the determination is really prospective in orientation. But for the injury, what would this employee likely have continued earning?
Well, we know that during the period in which he was injured, he was earning at the full contract rate, not at some annualized rate. And I'm stretching to even see why 12 months would be the denominator. Why not 24, 10?
Let me address that. First of all, the use of an expanded wage base in general. We will do that when we're fairly confident that the 30 days does not accurately reflect the person's earning capacity in that occupation. And the courts have told us that the Commission has a fair amount of discretion in making that determination. I reread with interest a comment made by the Supreme Court in the Powell case that normally it's not appropriate to use just the 30 days to establish the average monthly wage. That doesn't give you enough of a sample size to make an average. It's the more recent cases by this court that talk about the 30 days being the presumptive wage base. So it's interesting trying to reconcile the Powell comment on that point with the more recent comments by this court. But having said that, in my experience at least, and as shown in this case, if the 30 days before the injury really skews the numbers, gives you an inaccurate assessment up or down of what this person was likely to continue earning, that means we can use an expanded wage base.
Well, but this person was likely to continue earning that amount of money for the entire contract period on a monthly basis. So I'm struggling to find the legal basis for annualizing. I mean, isn't the real measure what the person was likely to earn as an average monthly wage, period? And an average monthly wage, I mean, any of us could lose our jobs at any moment. So isn't your average monthly wage what you're reasonably likely to continue earning in the future, not what you might say you earn in a year?
I guess my best answer is normally the commission wants to use a more expanded wage base. If you look at the Powell Court, for example, they in fact talk about the commission's use of an expanded wage base of 365 days. The statute doesn't tell us that you can use 365 days. I recognize that. But if you read Powell, Powell refers to Larson. The orthodoxy is to use 365 days. And I can tell you that in the old commission's claims manual, which is attached as an appendix to the handbook, they just flatly state we use 365 days. That's been the orthodoxy for as long as I've been practicing in this area. It's not invariably used.
But they didn't hear. I mean, they took your recommendation, right? They took your recommendation and said this is they accepted your notice of wage determination and just said it, right?
Well, they did initially, and we protested it. And that goes to a burden of proof question that the court raised in advance of this oral argument. So let me address that. I have a citation for you, and it's a case called Bratz, B-R-A-T-Z, versus Industrial Commission. The citation is 178 Arizona, 359, 873 P. Second, 697. That case dealt with an average monthly wage that was protested, and then the question was, what's the probative effect of the interim award of the Industrial Commission's Claims Division? And basically, the court held in that case that once an average monthly wage determination of the commission is protested, it's a nullity. Now the ALJ has to decide the case based on the evidence that's actually submitted to the court. So
did the carrier appeal that?
We did.
In that case? I mean,
oh
no, in that case. Because I've seen very few cases, if any, where the carriers actually appealed the average monthly wage determination.
I'll grant you that. It is unusual.
Okay.
So what happened in this case, the young adjuster recommended a wage. Shortly afterwards, the HR director for Ballet Arizona got wind of it and expressed concern and said, I think you've overstated what this person was actually making. It was on that basis that I then requested the hearing. Once that was done, the interim award of the Claims Division at that point is a nullity under the Bratz case, and now the case has to be decided based on the evidence that's actually submitted.
Okay, understood. If you're trying to just go back a little bit to where we were a couple minutes ago, if you're trying to distill this down to, I mean, all these cases, starting from the 1930s, going back about average monthly wage, and it seems like every court struggles with how to interpret this statute or apply it, but at the end of the day, and it seems like there's a jumping off point to go to the exception, seasonality, intermittent, or it simply doesn't accurately represent the wage base, and you have to go for extended wage base. And it seems like you're suggesting seasonality. That's what you relied on. That's what the ALJ relied on, seasonality. There's one case, at least my research revealed one case that actually applied seasonality, the Baker case, the cotton picker, 69 years old, picked cotton, did not want additional wages because it would affect his Social Security. Are there any other cases that support you, or is that the best one?
You know, I can't think of any other cases off the top of my head at this moment, but let me point out that the calculation here was a little more complicated than what you've just posited, because we had concurrent employment, which kind of changed the equation. So what I urged to the ALJ was look at the Ballet Arizona employment as seasonal in nature, in the sense that it was only available during a certain season of the year. I have to tell the court that evidence was uncontradicted. Both the claimant and the HR representative of Ballet Arizona said, that's right. Once the season is done, the ballet companies don't have any performances.
Did she testify as to companies, or did she testify as to Ballet Arizona?
I think she was specific to Ballet Arizona, and she was really...
And doesn't the case law council talk about industry standard? I mean, most Powell and Pettis, don't they look to what's going on in the pipeline cases or the agriculture cases or teachers cases? Aren't they looking what does the industry do? Is work available in that industry?
And in that industry, in this local area, not just nationally or internationally. So you would be more focused.
Is there a case that says local area?
We do have cases that talk about local area, and I can't cite them to you. I know Powell brushes across that, but I wasn't really focused on that. But I agree with Mr. Crossman on that point. We don't set an average monthly wage based on what somebody in New York City might earn in the ballet. We look at what Arizona has available in that industry. And I will agree with you. Kathy Chanowanich, I think was her name, said this is what Ballet Arizona does. The contract talks about the season. But when we posed that same question to the claimant himself, he agreed with it. He agreed that this is seasonal employment. What's different about this case is this. Concurrently, he taught in his father's school. That's the instructor position. We granted him that. We didn't argue about the point. We said, we'll give you the $1,000 a month. So what I argued to the judge was, do a seasonal calculation for the Ballet Arizona, look at the $1,000 a month, take 365 days. There's your calculation. He probably made $3,300 a month on the average over the year.
What policy does that advance, though, that's consistent with the statute? To annualize seems to be a concept that we simply import culturally, but it's not in the statute. The statute talks about average monthly wage.
But it makes sense because we're trying to compensate people consistently with their earning capacity. I'm not a mathematician, but this pithy example occurs to me. Take somebody who only works 2 months out of the year. He's only worked 2 months out of the year for 10 years. His contract provides for $1,000 a month. He only works 2 months. Are we to set the average monthly wage at $1,000 or $166? What really reflects the loss to him in that employment?
What if it's 3 months or 4? I mean, are you suggesting that there's some point at which it just becomes, a teacher, we say is not seasonal, right? Are you saying that there's some magic point at which we go from seasonal to not seasonal?
Well, seasonal is traditionally identified as employment that's only available during certain times. My suggestion is this. If you end up with an average monthly wage that reflects an income that's demonstrably greater than this person ever earned, you've made a mistake in the calculation.
Has that happened here? Or would Mr. Wozniak's proposed result make that happen?
Yes, and let me tell you how.
Why so?
Yeah.
If you look at the earnings in the 30 days before his accident, he made $3,080 with Ballet Arizona and $1,000 with his dad, $4,080. If you extrapolate over the year, you come out with an annual income of $50,000. That's not what he made. He made
but if you
$40,000.
extrapolate, we could extrapolate out over 2 or 3 years and figure out higher or lower numbers speculatively. But if the question that the law directs us to answer is how much was he likely to earn in that month, and you've done the math for us, how are we arriving at a number that is higher than what he was likely to make in that month?
For that reason, if you give him an average monthly wage of $4,100, which is what he's advocated, you come out with a greater earning capacity than he in fact demonstrated.
Right,
that was my
let's say
point.
let's say that we have a ballet in Arizona that has a pit orchestra, and he's a violinist. Okay, same numbers and everything, but there's a greater chance that a violinist might find orchestral work in the off season. Does the analysis change, even if he doesn't have a contract for it?
That's exactly what we did here. That's concurrent employment. That's probably
No, not concurrent. Successive.
Staying with the same ballet company, but instead of dancing, he's now employed in another capacity.
No, just employment in the field of violin playing.
So he moves
Because
from
there
one
might
job
be
to the next.
there might be other employers. There might be a show in town that needs a violin player, and so he could get work when the ballet isn't in season.
Sure.
Would that change the analysis?
It's the same analysis, and that's how I read Powell. The Powell court was very concerned about the fact that these teachers can, in fact, work during the summer months. And they were really concerned, as I read this court's opinion and the Supreme Court's opinion, limiting the average monthly wage to 9 months. The thing that I find puzzling about Powell is that there was never any real discussion about whether the teacher in that case, in fact, worked in the summer months. It was just an assumption, which I've never quite understood.
Well, it's safe to say that I find that puzzling too, and that's why I'll ask you the same question. What's the basis for the distinction between a farm worker and a teacher?
My best answer is Powell seems to be a unique case. A standalone
Seems to be
case.
what?
Unique. A standalone.
Is it sort of silently adopting a special rule just for teachers because we like them?
I really hesitate to embrace that idea, but it makes sense to me because of the heavy emphasis on teaching in that case.
Mm-hmm.
I haven't found any cases since then that have adopted that same analysis.
But assuming we're not going to embrace that because it would be an arbitrary rule, right? I mean, it may appear that way on the surface, but assuming we don't attribute that arbitrariness to the court, we're dealing with a teacher who works about 9 months out of the year, and Mr. Wozniak has an eerily similar schedule. Why wouldn't those two cases seem factually similar enough to apply them?
Well, the distinctions are, as we've urged in our brief, number one, the record in this case establishes that the kind of performance he was doing for Ballet Arizona was not available during the off-season. In contrast, in Powell, the court made a big point of the fact that these people can continue teaching throughout the year. Again, I'm a bit perplexed that there was no such evidence actually in that case, but that seems to be a major point of emphasis. The other thing here is we, in fact, have concurrent employment. We know he had other employment during the off-season, and in fact, during the season, we combined all of that together to come up with an average monthly wage that seems to be fairly reflective of his earning capacity and not an exaggeration, which is what we were trying to avoid by this.
And I understand if you're concerned about exaggerated wages, but didn't the legislature take that into account when they put a cap? When they put a cap on everybody's wages, that said, so you have a high-income individual, say an athlete, baseball player, football player, their season is very defined, right? We know that. The NFL, Major League Baseball, they are injured, and let's say that they have a contract just for the season, they're injured, that's going to be way overstated, right? Their monthly income is going to be way overstated, but it's capped. It's capped, right? The legislature has put that in. So, all things being equal, did the legislature intend for us to go through these gymnastics? I mean, like really trying to do mental gymnastics on every one of these. I guess these seem to be difficult, and
well,
I'm wondering if they should be so difficult.
We spent a lot of time on average monthly wage issues. Let me tell you that. I think the legislature, in lieu of trying to address every conceivable situation that might arise, wisely let the Industrial Commission have some discretion here. And generally speaking, they do pretty well. We have some of these cases that are litigated, but not very often. We have two people sitting down at the Industrial Commission right now, and all they do day in and day out is average monthly wages, and they get pretty good at it. But to your point to the cap, Powell again talks about this as I reread the case. The whole point to the cap was to discourage people from malingering. It wasn't intended to be complete.
From what, counsel?
From malingering.
Thank you.
So the whole idea was we didn't want to provide them with complete wage replacement because that might serve as a disincentive for somebody to get well and go back to work. Maybe that sounds like a quaint notion, but that was traditionally the reason for the caps, which plays into what we're talking about here. If you elevate this young man's average monthly wage, keep in mind he gets 2/3 of it and it's tax-free. At what point is he in effect getting what he was netting before? That defeats the whole purpose of the average monthly wage calculation.
Well, there's no suggestion in the statutes that the taxes should be taken into account, is there?
It's not in the statutes. I'm just bringing it to the court's attention as a factor to consider.
That would be the court sort of making sure that one way or another, even if you're not paying your taxes, you're paying your taxes. That would be an upside-down policy, wouldn't it?
Well, my point is a little bit different. My point is we want somebody to want to get back to work. If, as a result of injury, you're providing him with complete wage replacement, that's the disincentive that was, and the cap was intended to address. That's how I understand the law.
A couple of questions. First of all, can you tell us, did Ballet Arizona cover Mr. Wozniak full year-round with workers' compensation coverage? Because the only reason I bring that up, that the Powell cases discuss that, and it goes way back about the history, and I know you have a lot of history, but yes, I mean, can you tell us whether there's year-round coverage?
That's a puzzling part of the Powell discussion. And I have to tell you candidly, we don't have anything in this record that talks about underwriting. That's really an underwriting question. I can tell you, based on my own personal experience, a company like Travelers will insure a company like Ballet Arizona for a policy period. It provides coverage to the extent required by Arizona law. It's pretty broad coverage.
Is that policy period a year?
It's typically a year. Sometimes I think it's typically a year. We don't even have the policy in this record, so I can't tell you for sure. But it's a policy period.
If he comes in on the off season for a meeting, just to discuss the arc of the next season and trips, is he covered?
He's covered. He's certainly covered.
In the off-season?
If he's there on work-related activity, we have a lot of this.
Or if he's going to the doctor to get his certificate of fitness for duty, is he covered on that?
I have to think about that.
If he's not being paid for that meeting. I mean, he's in the off-season, he's not being paid for the meeting, but he comes in just to kibitz about the upcoming season. Is he
Yeah.
covered if he
I get
injures
these calls
himself?
all the time from my clients, and I have to think about it, so I don't know.
But
If there
the-
was some degree of compulsion,
But the file is clear in this, the record is clear in this, that if he is working at his dad's studio and he's injured, he's not covered, correct?
he's not injured in the course of employment with Ballet, Arizona.
Okay.
So the touchstone there is not the policy period or whether he was a named insured. Employees aren't named insured.
So even the additional income that he's given credit for in the course of calculating the sums, there's portions of that additional income that would actually, the benefit would, what am I trying to say? They would have an aspect of coverage here and elements, components of his income that didn't have coverage, elements of coverage.
Well, that was the whole problem with the concurrent employment issue. When we were starting to combine concurrent employment, obviously travelers...
You're better with that word than I was. That's the word I was looking for.
Concurrent.
Thank you.
Well, obviously, the traveler's policy looked at these risks, and yes, the risk would factor in the fact that some of these people only work part of the season. That would go into the overall. But it's a year policy. They have more than just answers. And I can't be any more specific than that. But if he's hurt, he's paid the year-round comp benefits. Comp benefits aren't limited to the season. He gets the comp benefits as long as the disability lasts. That's how it works. That's an old Supreme Court case called Shaw. So I don't think that's relevant to what we're talking about, whether there's any underwriting problem here. We don't have any evidence of it anyway, but it's not an issue for us. I did want to take one quick furtive stab at 1041C, which I've never really quite understood. It talks about contract wages. It talks about guarantee wages. It talks about the wages of employees in similar activities not under contract. It seems to refer to a particular situation that's obscure to us now. I thought a contract wage is a guaranteed wage, but it must be something else. And as I look at the old cases, they talk about the guarantee wage and then the contract wage as being maybe bonus incentives. And then the courts that talk about those cases, that particular statute, wrestle with whether in a particular case the average monthly wage can be limited only to this so-called guarantee wage or should include the bonus payment that in fact the claimants may have gotten in a particular case. It's not really relevant to what we're doing here. This young man received nothing other than the contract price. He didn't get any sort of bonus. There's no argument that we didn't include or consider all of the money he was making.
Thanks. We're out of time.
All right, thank you.
With reference to the premiums, no individual is on the premiums. They figure all the salaries that are paid, and then they take 1 point or $1.20, $1.50, depending upon what the loss ratio is, and that's what they apply to. It's not a particular period of time. They apply it to that policy. So that's number one. Number two, I think it's important to recognize, if you look at this as he's entitled to 66 2/3% of his average monthly wage while he needs active medical treatment, and 55% when he's on purpose. But if you use this figure that they've got here of $3,300, and you divide it by 66 2/3, or the 770 by 66 2/3, using the number that they use, he won't get 2/3 of his average monthly wage of $770 a month, of $770 a week times 4.33. So he will be getting less than the 2/3, and that clearly is an intention on the part of the statute and the courts to make it so he can get it, so he can make a living, rather than. So if you divide by 12 rather than 9, then you're not going to get the 2/3. Okay. Yeah. My definition of seasonal employment is employment that cannot be held for the whole year. All right? This can be held for a whole year. I mean, picking cotton can't be held for the whole year, nothing like that. And that's more of the common language of seasonal employment.
So you're just saying if a ballet studio wants to open for the year, they can.
Sure.
They can be open, they can present performances, their attendance might be down
Right.
certain periods. So you're saying it's the nature of the employment. Where did the seasonality come from? Do you know? What concept? Where did it come from? How did Arizona pick this up?
No, I'm not sure, Judge. I really don't know why there's such a distinction in that and why you have to divide by 12 months. Why not 3 months? Why not 2 months? There's nothing here that says 12 months is legitimate, especially since the job is only 9 months. Yes, sir.
I was just curious about the Pettis case. I mean, we can talk about is it workable for 12 months? Is it workable for 10 months? What is the limits? And in Pettis, the issue is timber cutting and the weather, right? Northern Arizona gets cold and we know that. And so because one employer is willing to work 12 months of the year and another employer is going to work 10 months of the year, there's a distinction in that in regard to the payment of these benefits? He could have worked for 12 months for
Right.
Mavis, what's his name?
And he actually did go afterwards. He didn't like this particular guy, Pettis, and went to work for somebody else.
Decided to leave the one guy because he could get more money with working the 12 months of the year.
And they divided it by 10 when the work was available in Pettis.
Okay.
All right, I've got 7 seconds, 6 to breathe heavy, but I think I'll forego that.
Thank you, Counsel.
Well, thank you both for your arguments. The matter is now under advisement. We'll issue a written decision in due course, and the court stands adjourned.